Support for WBUR comes from the Boston Symphony Orchestra. This month, the BSO presents the warmth of Brahms' Second Symphony, the drama of Dvorak's Cello Concerto, and the delight of Mussorgsky's Pictures at an Exhibition. Plus, Joshua Bell performs a rediscovered gem. More at bso.org. Support for this podcast comes from It's Revolutionary, a podcast from Massachusetts 250. A recent episode journeys to one of the largest reenactments of the American Revolution. Stick around until the end of this podcast for that episode.
WBUR Podcasts, Boston.
This is On Point. I'm Meghna Chakrabarti. On Inauguration Day, January 20th, 2025, President Donald Trump said, yet again, that his favorite word is...
Tariffs is the most beautiful word to me in the dictionary. Then I was reprimanded by the fake news. They said, what about love, religion, and God? I said, I agree. Let's put God number one. Let's put religion number two. Love, I don't know. We got to put that number three, I guess, right? And then it's tariff. Because tariffs are going to make us rich as hell. It's going to bring our country's businesses back that left us.
Since that day, the Trump administration has issued sweeping, aggressive, and wildly fluctuating new tariffs on almost every country in the world. From January to April 2025, the average applied U.S. tariff rate rose from 2.5% to an estimated 27%. The highest level in over a century. Now, this included tariffs on China as high as 145%, 50% tariffs on Brazil and India, 35% tariffs on Canada, 25% tariffs on Mexico, 30% tariffs on South Africa. The list goes on. According to the U.S. Treasury, in September, tariff revenues totaled more than $31 billion, bringing the total year-to-date figure to $215 billion. Now, recall, tariffs are paid only after goods have entered the United States, which means that the U.S. importer pays them. Those costs get passed on to you, the consumer, or companies so-called eat the costs. Or sending nations simply reduce how much they export to the United States. In other words, that revenue isn't necessarily coming from abroad. It's going to the U.S. Treasury from consumers right here and domestic companies. Now, all of this tariff-specific language actually ignores a huge legal question. And that is, are President Trump's tariffs even legal? Does he have the constitutionally conferred power to slap tariffs on the world? Because the tariffs themselves are not an issue. The U.S. uses them all the time. The issue is, who has the legal power to levy tariffs? The president or Congress? Well, tomorrow, the United States Supreme Court will hear oral argument over exactly this question. Here's President Trump on Sunday talking to reporters on Air Force One.
I think it's the most important decision, one of the most important decisions in the history of our country. Because without tariffs, without our being able to use tariffs freely, openly, and in every way, we would suffer tremendously from a national security standpoint. The national security of our country is at stake. I think it's one of the biggest decisions in the history of the Supreme Court.
President Trump added on Truth Social that same day, quote, "If we win, we will be the richest, most secure country anywhere in the world by far," all capital letters there. "If we lose, our country could be reduced to almost third world status. Pray to God that doesn't happen," end quote. But the Supreme Court's decision could transform more than just trade policy or the economy. And in this point, President Trump was right in that clip you heard. If the highest court allows the president to issue unrestricted tariffs without congressional approval, it would be one of the greatest expansions of executive power in this country's 250-year history. It would essentially give the presidency a powerful and unchecked tool that could be used against any country, any industry, any business, whenever and however the president likes. So today, we're going to examine the arguments the court will hear for and against this historic expansion of presidential power. And we begin with Lori Wallach. She's the director of the Rethink Trade program at the American Economic Liberties Project. That's a nonprofit in Washington focused on the concentration of economic power. She's also author of The Rise and Fall of Fast Track Trade Authority. And Lori has more than 30 years of experience in international and U.S. congressional trade battles. She's testified on this issue before Congress dozens of times. Lori Wallach, welcome to On Point.
Thank you very much.
So, first of all, elaborate as much as you can what you understand about the president's argument for the dire necessity of tariffs. I mean, you heard in that clip that he talked about, well, it's for national security. I mean, what more has he or his administration said that would support this national security argument?
Well, the rhetorical arguments and then there are the legal arguments. Mm-hmm. And the administration effectively is squabbling over what kind of tariff authority it has, because it's not an all or nothing at stake here. There are lots of clearly delegated tariff authorities where Congress has said if other countries are cheating on trade, for instance, dumping, selling below the cost of production, that's dumping, mm-hmm. or if a country is threatening national security and what they're doing with trade, or there is a product we need for national security. Congress has delegated authority for presidents to use tariffs, and the Supreme Court has tested those delegations and found them to be fine. Mm-hmm. At issue in this case is whether a president has entirely unbounded unilateral authority under a particular statute called the International Emergency Economic Powers Act, mm-hmm. or IEPA. And President Trump and the administration want that totally unchecked, unbounded authority because it basically provides rights to, as you said, unilaterally leverage any kind of threat or reward to any political ally or enemy, to any country, to any industry. Yeah. And that is an unbound tariff authority that is in question in this court case.
Okay, so we will really leaf through in detail IEPA in just a few moments, right? Because that is the central act that, as you said, will be debated before the justices tomorrow. But I just want to go back over what you said here a minute ago. The examples that you gave in terms of, there are instances which the U.S. has in the past used tariffs for literally for what the president is saying now, for protecting national security. But in every one of the cases you just talked about, or sort of test cases you talked about, Lori, you also said Congress says that in that case, issuing a tariff is, or levying a tariff is appropriate. The implication being that ultimately Congress has to provide the approval for tariffs.
Correct. So it's worth stepping back a little bit. The U.S. Constitution has one of the sharpest checks and balances in the entire document with respect to tariffs and trade. And folks, sometimes don't remember that in a way our country's independence was spurred along by a trade war. The Boston Tea Party was the colonial protest against King George's unilateral imposition of tariffs on tea and other imports. And the founders, with that enormous power of tariff in mind in writing the Constitution, in enumerating Congress's authorities, put not one but two explicit clauses of exclusive constitutional authority to Congress in Article 1.8, mm-hmm. so that the body closest to the people, a diverse group of people representing different parts of the country and different people, would set the policy, not the king, the president. So the Constitution says the Congress shall have the power to lay and collect duties, which is an old-fashioned word for tariffs, and the Congress shall have power to regulate commerce with foreign nations. So it's two separate, explicit, hey, Congress, you got this, not the president. Now, over the 248 years of Congress delegating authorities, there have been different ways Congress has said, okay, we've got this authority, but the founders gave exclusive authority to the president to represent us to foreign sovereigns, to negotiate internationally. This is the check and balance here. So we're going to delegate our control over the content of tariffs and trade policy with certain parameters so that they can do the talking to the other countries. And then we're going to make them come back and we'll approve what they did or not, depending. Even more important than those historic instances, I would say it's worth thinking about one of the arguments the administration is making now, which is President Trump says he needs this totally unbounded IEEPA authority for the sake of national security. Yet there is a statute that is in the Trade Act of 1962, Section 232, under which presidents have been delegated by Congress for decades authority to use tariffs in the instance of some national security threat. And the difference between that and IEEPA is there's more process, there's more oversight, and there's some parameters. So, for instance, in order to do a Section 232 tariff, the executive branch, a president, it's a delegated authority, has to have a process of doing an investigation and proving the actual threat at hand, and then coming up with a tariff that is justified by that threat. Not a lightning bolt, a useful tariff tool.
It's so fascinating. I was just looking at Congress's own website, congress.gov. And if you just do a simple search for tariffs, the first hit you get is a very well-written site all about U.S. tariff policy. And it says exactly what you said here, that over about roughly 70 or 80 years, Congress has increasingly delegated some tariff levying authority to the president. But it emphasizes through and through that it's Congress that sets the goals for the tariffs, but has given in some cases, the president the ability to negotiate those goals. And in fact, the congressional website says this is one of the things that has helped create a stable, rules-based world order when it comes to international trade. I mean, your thoughts about that?
Well, it's spot on, and you found your right partner in trade nerdhood here, because the history of it is fascinating. And, the book that I wrote talks about fast track. That was the most recent delegation. That was a much larger one than the previous. Congress used to very zealously guard this authority because they recognized the might of it. I mean, a president without using tariff authority, exercising this massive power without care or based on corruption or whim or pettiness or political just judgment that could be questioned, could destabilize the U.S. and global economy and undermine the national interest. So Congress used to really hold on to this authority in these statutes that exist now, where there are legitimate delegations, including all of the trade enforcement laws, dumping, subsidies. There are parameters, there are checks and balances that are still remaining. And that's why this court case is so important with respect to this particular statute, because what the president is seeking is an entirely unleashed control. So he ran saying that he was going to use tariffs to rebalance trade, rebuild American manufacturing, and boost U.S. industrial jobs. Those are all really important goals, which I actually share. I am not a tariff-phobic person, and I would contest some of even how you described who pays, because with this round of tariffs, actually, a lot of the foreign companies who are trying to sell us stuff are paying for all or some of the costs because we have such a lucrative market. That's the upside of having a $1 trillion horrible consistent trade deficit, is everyone needs to sell us stuff. So they'll negotiate on the tariffs. But putting that aside, tariffs can be a legit tool. The question is used how and for what purposes. And so you mentioned the 50% tariffs on Brazil. What's that about? We have a trade surplus with Brazil. We sell them more stuff. They're not part of our trade deficit problem that ostensibly President Trump's trying to fix. Why do they have some of the highest tariffs in the world? Because President Trump has unilateral authority, he thinks, to try and torment the current government because he's upset that they're trying to hold accountable the previous right-wing president who was part of a coup and had planned to kill most of the Congress and become a dictator in Brazil. And they're running a process there where they've sent him to court. He's been tried. He was prosecuted for this coup, as were a bunch of other people involved in it, and they're all going to jail. President Trump, like that guy, he's using tariffs to punish a country unrelated to our national interest in trade balance or manufacturing. Those are the abuses the founders had in mind when they said Congress, not the president, should have this authority.
Well, that the founders have in mind. You're creeping into originalist thinking here, Lori Wallach. I wouldn't have pegged you as a textualist.
Yes, well, what's funny is I actually think the weakest argument, the strongest argument for saying the president doesn't have these IEEPA authorities, and the weakest argument for the president is improbably actually a doctrine called non-delegation doctrine, which used to be used to try and undermine the FDR-era presidential powers that created the whole New Deal infrastructure and has not been used since. But it basically says if a delegation by Congress does such violence to some fundamental constitutional provision, check or balance, that it eviscerates it, even if Congress has given a delegation of that authority, it's still not constitutional. And in this instance, there's a lot of controversy about whether IEEPA actually authorizes tariffs at all or not. There are arguments on both sides, and we can go into them. But what clearly is the case is that if a president can use this unbounded authority the way Trump has demonstrated he does and will, then that cannot be constitutional given the checks and balances in the Constitution.
Support for On Point comes from Indeed. Hiring isn't just about finding someone willing to take the job. You need the right person with the right background who can move your business forward. To find quality candidates, give your job the best chance to be seen with Indeed's Sponsored Jobs. It boosts your posts so you can reach the exact people you want faster and spend more time interviewing candidates who check all your boxes. And On Point listeners will get a $75 sponsored job credit at Indeed.com/onpoint. Terms and conditions apply. Hiring? Do it the right way with Indeed. Support for this podcast comes from It's Revolutionary, a podcast from Massachusetts 250. What's more revolutionary than the American Revolution?
You know, if you stop and you think about the fact that you're free and you're in the United States and you're an American, it all started back then.
The show's season finale heads to Old Sturbridge Village to see how reenacting the revolution allows the public to live through history. Stick around until the end of this podcast for that episode, and follow It's Revolutionary wherever you get your podcasts for more stories.
Democracy under siege, Democrats treading water, and one outlet after another checking out.
All the big media giants are willing to fold.
Slate has never been afraid to tell it like it is and hold powerful feet to the fire.
We want to try to defend our communities, our families, our people.
But what if you can't? What Next asks tough questions without forgetting who's at the center of our work. You. Follow and listen wherever you get your podcasts.
Lori, hang on here for just a second, because this is a perfect opportunity, and thank you for setting it up, for us to talk about specifically the cases that are being argued at the court tomorrow. One of the plaintiffs in one of the cases is a company called Learning Resources. It's a small family-owned business in Illinois that makes educational toys. And here's CEO Rick Woldenberg in an interview with CNBC.
When they were at 20%, he had promised 60%. We figured maybe he would land at 40%. But when it went from 20% to 145, it just went completely off the rails. It's 2.5 times what he said was the maximum. And it's way into the stratosphere that no business could possibly handle. We basically stopped importing at that point, which is obviously catastrophic. The business is built on flow.
And in another case, but also within the tariff umbrella that will be heard by the court, one of the plaintiffs is a New York-based wine importer called VOS Selections. Here's owner Victor Owen Schwartz in an interview on MSNBC.
You know, you increase someone's taxes 5 times, it's going to have an impact. I was just looking, our second quarter since the strangulation day tariffs hit, our profit went down like 60%. 60. Where's that money going? It's going to the federal government. It's a tax. So it's like all of us small businesses, we have this terrible anvil on our head. And you start calculating what's that going to cost us through the end of the year. Now that we have, supposedly the set tariffs, 15% from Europe, 30% from South Africa. It's a challenge of cash flow it's hard to measure.
All right. Well, let's bring in Mark Joseph Stern now. He's senior writer at Slate. He covers the courts and the law. He's also co-host of the Amicus podcast. Obviously, it's a show about the Supreme Court. Mark Joseph Stern, welcome back to On Point.
Thanks so much for having me back.
Okay, so Mark, help us understand here, like in recent court cases that had to do with President Trump and the overall question of executive power, has there been a pattern to how the court has ruled?
Absolutely. The court has very consistently ruled in favor of Trump's broad claims of executive power in a series of decisions over the so-called shadow docket, so cases without oral argument or full briefing. The Supreme Court's conservative supermajority has consistently said that Trump is able to do almost everything he wants to do, including consolidating a lot of authority in the executive branch that has traditionally belonged to Congress, including power of appropriations and spending, as well as firing and replacing various federal officials at independent agencies like the Federal Trade Commission. So this is a court that over the last 10 months has generally been pretty favorable toward Trump's claims of executive power. And the big question is whether that will all come screeching to a halt now that the question is tariffs rather than a matter that the conservative legal movement has generally agreed upon in the past.
Oh, interesting. Okay. Now, can you just briefly summarize to us how this case landed before the Supreme Court, right? Because it had to make its way through the lower courts. What were those lower court rulings like?
So all of the lower courts ruled against the Trump administration and in favor of the small businesses we just heard from. And the courts generally found this was not a particularly close call. They used different tools of interpretation that we can talk about. You know, when you're interpreting a statute that's very, very broad, like IEPA, it can be a little tricky to figure out exactly what Congress intended and where Congress wanted to draw the line. But the lower courts overwhelmingly said, look, this crosses the line. Wherever it is, it's pretty clear to us that Congress did not intend to give the president unbounded authority to issue any tariffs he wants for as long as he wants, based on his own sort of whimsical sense of what constitutes a crisis.
Lori Wallach, this is where I'd love for both of you to actually kind of help us clarify some terms here, because you've both said that a ruling in favor of the president from the high court could essentially give him unbounded authority. But that would only be one potential ruling, right? Is there, I think you had mentioned before, there's another path that the court could follow that would maybe limit the impact to just tariffs? Or did I mishear you?
Well, there are a lot of moving pieces, is how I would put this. Right. So the kind of decisions that could come down, for instance, if they're focusing on what is or isn't an emergency, you could have the recent action in the Senate being taken by the court. It will certainly come up in oral arguments. The Senate has, under a related statute, IEPA works where basically a president has to declare an emergency under another statute called the National Emergencies Act. And the National Emergencies Act has an emergency break where Congress has a privileged vote to try and say, no, it's not an emergency, Mr. President. It's basically was an added check and balance on whatever authorities of IEPA, including the tariff authorities that may or may not exist. And the Senate has now voted that the across-the-board tariffs don't have a justified emergency. The Canada tariffs don't have a justified emergency. Those are supposed to be based on fentanyl crisis issues, which is a real crisis. But Mexico, Canada, and China are fentanyl tariffs. The rest of the world is under a broad economic emergency of imbalance. And then specifically the Senate has said, no, Brazil is not an emergency that qualifies for this use. So the court could say it's not an emergency in these instances. We'll allow China and Mexico tariffs to allow. We're going to say the statute does allow tariffs. We'll allow Mexico and China to have an emergency set of tariffs. Everyone else, nope, your tariffs end. And then they'd have to use a different authority to come back and try and put those tariffs in place, which, by the way, key giveaway, I don't think the tariff situation is going to change a lot. The power situation could.
Now, the scope of the president's power. This court, in a very similar sort of formation in terms of the balance of political views, has taken up the issue of presidential power in other administrations, right? I mean, just in the Biden administration, when Biden tried to cancel all student debt or stop evictions during the COVID pandemic. And then, of course, there was a famous case about President Obama's clean air initiatives, right? Greenhouse gas initiatives. I believe in all of those cases, the court ruled that the president was overreaching, that he did not have unilateral power to enact these sweeping policies, correct?
Yeah, that's right. And in those cases, the court invoked a principle that's very similar to the non-delegation doctrine that Lori mentioned earlier. It's called the major questions doctrine. And the basic idea here is that when Congress wants to delegate decisions of vast economic and political significance, that it needs to do so really, really clearly. The executive branch can't just seize upon a kind of vague or broadly worded statute as the basis for some novel initiative. Generally, the courts are going to look to Congress to, as explicitly as possible, that the president can undertake this policy. And that was the basis, again, for the court striking down, as you said, student loan forgiveness, climate regulations, the evictions moratorium during COVID. All that stuff fell because the court ruled that Congress didn't authorize it clearly enough. And that is the primary argument that the plaintiffs have raised in this case, that under the major questions doctrine, Congress just didn't say clearly that the president could slap these tariffs on any country anytime it wanted.
Well, I was down on my last dollar and then I started saving because the bank said fiscal restraint is what you're craving. So I put my earnings in a high yield account. Let the savings compound and the interest mount. I'm optimizing cash flow, putting debt in check. Now time is my friend and not a pain in the neck. And we've got a little cash to rebuild the old debt.
Boring money moves make kind of lame songs, but they sound pretty sweet to your wallet. PNC Bank. Brilliantly boring since 1865.
From Curtis 50 Cent Jackson.
Tommy back.
Yeah, I am. And the executive producers of Power.
There's levels to this game.
Comes the final season of Force.
We're gonna have to be careful about our next move. We get what we can now and take the rest later. This is gonna be the battle of our life. It's go time.
This is a dangerous life that I choose to be in with you.
Force.
Never bet against me, because I'm always winning.
Premieres November 7th, only on Stars and the Stars app.
America is changing, and so is the world.
But what's happening in America isn't just the cause of global upheaval. It's also a symptom of disruption that's happening everywhere.
I'm Asma Khalid in Washington, D.C.
I'm Tristan Redman in London, and this is The Global Story.
Every weekday, we'll bring you a story from this intersection, where the world and America meet.
Listen on bbc.com or wherever you get your podcasts.
Following up on that, Mark, and Lori, I promise I'll come back to you here, but in the cases of the Biden and Obama policies, if memory serves, it was sort of that typical conservative liberal justice split, right? And then in those cases, the liberal justices said, no, we actually believe the president has such power. I mean, does that mean that we have the likelihood of this tariffs case being, I'm trying to hold back my skepticism here, Mark, but being one of the most just sort of nakedly political decisions the court's going to make in a while, because we have an example in equally high-profile cases of what is essentially a conservative-liberal split. We could see the justices vote in the or decide in the exact opposite way, right? The conservatives might say, no, the president has the power. The liberals might say, no, he does not. I mean, then, like, that kind of just throws the idea of a fair legal, examination of the facts of a case kind of out the window.
I certainly agree. I think there's an issue for both sides of the court here. I will say that I personally think that this is an easier case than the ones I just mentioned. As Lori said, there are other statutes on the books that do explicitly authorize tariffs to protect national security, to address trade imbalances, but Trump has not invoked those statutes because they are too narrow to accomplish what he wants to do. He has instead turned to this other oddly worded emergency statute because he thinks that it writes him a blank check. I think it would be consistent for the liberal justices to say, look, in the past, we thought that the statutes were clear enough, but here it seems just blindingly obvious that the president has circumvented the procedure that Congress laid out because it didn't give him enough authority. Now, on the other side of the court, there's this big question about whether the major questions doctrine applies when there is a matter of foreign policy or national security. And so, student loan forgiveness, climate regulations, that's bread and butter domestic policy. And so the Supreme Court said, this is just a matter of, what Congress wants. It's simple. It didn't want this. But here we've got the president saying over and over again, national security, foreign affairs. And this Supreme Court has ruled that the president's powers are at their zenith when he is trying to protect national security or dealing with foreign affairs. And just last term, Justice Brett Kavanaugh indicated that he doesn't think the major questions doctrine applies in the realm of national security and foreign affairs. So it's possible that the conservative justices, or at least some of them, could flip and after striking down many Biden policies under the major questions doctrine, say, oh, well, it doesn't apply to Trump here because this is all about foreign powers and we're not going to, micromanage his efforts to protect the country on this front.
Well, I mean, this would be legally consistent if the court had also issued rulings that restrained President Trump on the domestic front, but it has not.
Right. That's exactly right. I think that one searches in vain for consistency in this realm because, frankly, the major questions doctrine is a very kind of freewheeling idea that allows for judges to use one subjective sense of what counts as a big question. Student loan forgiveness was $400 billion. That's a lot of money, but Congress regularly passes, multi-billion, multi-trillion-dollar bills now. What counts as a major question is in the eye of the beholder. And a lot of us court watchers get nervous about that because as soon as subjectivity creeps in here to the judicial analysis, it gives the justices an opportunity to substitute true textual interpretation with their own policy views.
I think a lot of people listening to this are like, well, this has to do with tariffs. Why are they jumping to it would be equivalent to a massive sort of taking off of the shackles of presidential power? I mean, the connection perhaps is not so clear. So why do you think that a ruling on tariffs would be, an historic expansion of presidential power?
So, counterintuitively, a ruling that IEEPA is not allowed isn't going to make that much of a difference because, as Mark Joseph Stern just said, there are other statutes. And immediately, Section 122 of the Trade Act of 1974 allows a president to do 15% tariffs on the whole world for up to 5 months. Then there is the national security tariff I talked about that requires an investigation you could do in those 5 months. So if they say the tariffs are not allowed under IEEPA, it's not going to be an enormous change. The reason why it's going to be a sea change if they say it is allowed is because this particular authority, as used by President Trump, is far beyond a tariff question. For instance, right now, if you think about it, why does the president want this IEEPA blank check as compared to using all these other statutes that could do the same thing? Because IEEPA allows him on a whim to threaten a country, tariffs on you if you dare to break up big tech monopolies, because I like those companies. They paid for my inauguration. You bust monopoly abuses, I tariff you. Tariff on you if you require big pharma to charge affordable prices. Tariff on you if I don't like your socks, Justin Trudeau. I swear the original Canada tariffs, there's not a big fentanyl problem with Canada. It seemed to be a grudge about Canada and Justin Trudeau, or last week, literally threatening 10% more tariffs because President Trump didn't like a television ad that a particular Canadian province's premier had put up on the World Series. Premier Ford put up an ad that used a Ronald Reagan audio clip saying that tariffs were a bad idea. And Trump was in such a rage, he threatened 10% additional tariffs on Canada. That kind of, I don't even know what the right adjective is, whimsical seems too gentle, use of petty, personal, not thinking of the national interest, use of tariffs not only doesn't do what Trump promised, which we do need to do, rebalance trade, rebuild our manufacturing resilience. That's a matter of not just national security, but climate crisis resilience. We need to be able to make more things. That's a good thing to do. His use of tariffs have nothing to do with any of this. So the reason why the power grab is so enormous is what tariffs can do goes well beyond actual economic questions to just being a lightning bolt threat of if you don't do what I say, by the way, also U.S. company, sector of the economy, other country, I chuck a tariff at your head.
Mark Joseph Stern, we have talked in detail about the reasoning why IEEPA is maybe not a statute that confers that kind of power for the president. Can you summarize to us what argument the administration is making that they say it does?
So the administration is making, I would say, more of a rhetorical argument than a legal argument, frankly. I mean, the legal argument is that, the statute mentions importations. It says that the president can regulate foreign importations and that tariffs are a kind of regulation. Now, in fact, no previous president has ever interpreted the statute. No previous administration has ever used IEEPA to impose tariffs. And in fact, the way that Congress seemed to envision it was more about sanctions and embargoes and the kind of thing that past presidents have used it for. But the administration says, look, the courts need to defer to the president on what counts as an emergency that justifies the statute. And it's not for unelected judges in their ivory tower to tell the president that fentanyl and trade imbalances are not an emergency. This president was elected after a campaign in which he said quite clearly, fentanyl and trade imbalances, that's a concern for me. I'm going to address it on day one. And so what you see from the Justice Department, and this is quite unusual, by the way, this is a feature of Trump's Justice Department that we haven't seen in the past, is really a political argument that's thinly veiled in legalese. It's the idea that, courts had better let Trump do what he wants to do because he thinks that these are emergencies that are killing the country. And if courts stop him, then they're going to be responsible for all of the ruin that follows. It's a really odd way for the Justice Department to present an argument to the Supreme Court. Again, highly unusual. And I'm not sure that the justices are going to respond very well to it because they expect reasoned legal analysis from the government's lawyers. They don't really like it when the government's lawyers just take a Trump campaign speech and reword it to include a little bit of Latin.
Now, the thing that is, just going back to what Mark was saying, that the thing that's tricky is there is this language about regulate importation. You asked what the argument is of the administration. And what they're saying is that language, when it was used in a previous statute called the Trading with the Enemies Act, which was used by President Nixon to justify his across-the-board tariffs in the 70s, which were 10% and lasted about 6 months for a big balance of payments crisis. It was a period where we were going off the gold standard. That case, which is called Yoshida 2, by the Supreme Court, basically post facto, because Nixon had already ended the tariffs, said regulate importation allows tariffs. And so the thing that's tricky is that exact language, regulate importation, was imported into IEEPA and is also there. So what the administration is arguing is, hey, if it was good for Nixon, why isn't it good for us? And there are a lot of good arguments of why it's not a proper parallel if you want to get into the statutory interpretation. But that is sort of the legal argument that is their strongest argument. Otherwise, it's a lot of histrionics in their brief.
Got it. Unfortunately, we only have a minute left. And Mark, I want to give the last question to you because this court has oftentimes said, and of course, conservative legal scholars have said, we don't want to look to the courts to legislate from the bench. Don't ask the courts to do the work of Congress. But there's a very big difference between that and issuing decisions that affirmatively expand presidential power, right? And is it fair to say that this current court, instead of being more hands-off and letting the fight take place between the executive and the legislative branches, is actually being quite active in terms of presidential power?
Yeah, I completely agree with that. I think that what the court has been doing is transferring more and more authority from Congress to the executive branch, to the president. Previously, authority over appropriations, authority over independent agencies, and here it could be authority over taxation. Well, the power to tax is the power to destroy. So if the Supreme Court won't draw a line at letting the president impose what are effectively unilateral taxes, it's really hard to see when the Supreme Court will tell Trump, no, you cannot do this.
Mark Joseph Stern, senior writer at Slate and co-host of the Amicus podcast. Thank you so much for joining us.
Thanks so much for having me on.
And Lori Wallach, author of The Rise and Fall of Fast Track Trade Authority and director of the Rethink trade program at the American Economic Liberties Project. A great pleasure to have you, Lori. Thank you so much.
Thank you.
I'm Meghna Chakrabarti. This is On Point. President Trump's supporters call him a heaven-sent savior. His critics call him an authoritarian. But the U.S. is still a democracy. So to understand how Trump is transforming the idea of government by the people and for the people, it's critical to first understand what Trumpism is itself.
It is a form of government that is the antithesis of bureaucracies, which are answerable to the rule of law.
That's on the next On Point.
Think Verizon, the best 5G network, is expensive? Think again. Bring in your AT&T or T-Mobile bill to a Verizon store today and we'll give you a better deal. Now, what to do with your unwanted bills? Ever seen an origami version of the Hollywood sign? Jokes aside, Verizon has the most ways to save on phones and plans where everyone in the family can choose their own plan and save. So bring in your bill to your local LA Verizon store today and we'll give you a better deal. Rankings based on Root Metric True Score report dated 1H2025. Your results may vary. Must provide a postpaid consumer mobile bill dated within the past 45 days. Bill must be in the same name as the person living in the deal. Additional terms apply.
Support for this podcast comes from It's Revolutionary, a podcast from Massachusetts 250. Follow wherever you get your podcasts and listen on for our season finale, all about reenacting the American Revolution.
You're listening to It's Revolutionary, a podcast celebrating 250 years since the shot heard around the world was fired right here in Massachusetts. I'm Jay Feinstein. From revolution to revolution, we're exploring the people and places in Massachusetts that shape America. And that's a real cannon, fired during Redcoats and Rebels, a reenactment of the American Revolution at Old Sturbridge Village in Sturbridge, Massachusetts.
We see some Redcoats charging. They're running towards something.
This was a fitting trip for our season finale, because in Massachusetts, what's more revolutionary than the American Revolution?
It's so revolutionary because it's the first time in the 18th century we see people starting to act on the ideas of the Enlightenment and trying to think of ways they can, as a society, exist at a higher level.
Old Sturbridge Village is a living museum that generally reenacts 19th century rural New England. But this yearly reenactment squarely fits within the village's mission, according to Derek Heidemann, Director of Collections and Research.
One thing that's interesting about the early 19th century is it's when you first actually start to see reenactments of the revolution. So in the time period, if you go out to Redcoats, you'll see lots of American militia groups that are out there. And the American militia system continues on after the revolution and continues to evolve. So the nation is still largely defended by militia in the 1830s. And twice a year, they would get together for inspections and for regimental reviews. And very often at the fall muster, the regimental review, where they'd have lots of different militia companies, it would be just like going to Redcoats, except 1830s uniforms instead.
That's why more than 200 reenactors, dressed in their finest revolutionary garb and full of energy, came together to embody men and women who could have never imagined a microphone like the one I'm using right now.
I don't recognize that kind of artillery.
Dave Gibson is a reenactor with the Lexington Minutemen.
I represent a man on the green called Caleb Harrington. He was actually only 23 at the time of the battle, and he was killed on the green. So typically, every member gets assigned a person that was there. You research them, you learn the bio about them, you try to represent them.
So what is it like reenacting in Massachusetts, knowing that the revolution started in Massachusetts?
Well, it is really great. I mean, it started here, and that's why I was attracted to Lexington myself, because that's the first battle. The green where it happened is still there today. We reenact the battle on the green. So 250 years ago, these men died right here. So it's really, if you stop and you think about the fact that you're free and you're in the United States and you're an American, it all started back then with this idea and men standing up on that green and challenging, the British forces that were coming through.
The culmination of redcoats and rebels is a reenactment of a revolutionary battle. But plenty of reenactors are here to portray something else.
What are you making?
I'm working on a coffee pot.
I'm working on what is called a Dorset button or thread buttons. They originate.
Are you making something?
I am trying to decide on how to trim my straw hat here.
These artisan reenactors are just as passionate as those portraying soldiers in helping the public live through history. Just ask Derek.
For me, the most relatable things for the public are the things that were just kind of the mundane tasks, you might say, the things that people did every day without thinking about it, because it was just what people did, just like we all do with our lives today. And so I think reenactment is really important because it's that way of actually trying to access the past in a way that is far more tangible, far more contextualized than just reading a book. That's very important, of course, and learning more about our history is very important, but that's the strength to me of living history and doing reenactment.
For Dave, it's all about pride. What's something you hope people come away with after this event?
I think, for me, pride. You're coming and you're seeing how it started, and this is a great country. And 250 years ago, there was an idea, right? And it all started with, we didn't want to pay taxes without representation, but it's evolved over time. And just stepping back in time and seeing this is how they were, this is how they dressed, this is how they acted. And 250 years later, we have the internet and all these other things that just no one could have comprehended back then. So it's just the evolution of time is just very interesting to see, and giving the crowd the perspective to look in at what that was back then and ask questions and learn about it and see if they have interest in it to keep this legacy alive is, our overall objective.
It's Revolutionary is a podcast for Massachusetts 250. For more stories, follow It's Revolutionary wherever you get your podcasts, or head to wbur.org/MA250.